SJC-11535, Commonwealth v. Jonathan Niemic.
Good morning, Your Honors.
Hang on a minute.
Why don't you wait 1 second till we are all set for you?
Thank you, Fran.
Now, Mr. Reardon.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Jonathan Niemic. The first issue presented today is that in instructing on Murder 1 and Murder 2, the judge did not tell the jury that the Commonwealth needed to prove the absence of excessive force in self-defense. The judge instructed on self-defense.
Well, he did. You mean I see what you're saying. When he's describing malice, is that your point?
Well, at no point did the judge instruct on excessive force.
I thought he did when he was talking about manslaughter.
At the very end, in manslaughter, yes,
Yeah.
but not at all.
Not in connection with murder.
Yes,
yeah, okay.
yes. So the judge discussed self-defense, but there was no discussion about the consequence if the defendant used excessive force in self-defense. And then in instructing on Murder 1 and Murder 2, there was no mention of excessive force in self-defense. In light of the fact that this was the defendant's sole defense, and in light of the fact that this was the Commonwealth's burden of proof that it was not instructed on, the jury was not instructed on, there was a substantial risk, a substantial likelihood of a miscarriage of justice in not properly instructing the jury. Now, the judge did instruct at the end of the manslaughter instruction about how if there was excessive force, that would qualify for the manslaughter instruction. But that in no way corrected that it was an instruction that the Commonwealth needed to prove relative to Murder 1 and Murder 2, the absence of excessive force as an element of its case on either one of those counts. So that did not help out the Commonwealth's case in the defective charge. The manslaughter charge was also defective in that...
But the judge did instruct that they had to prove, that the Commonwealth had to prove the absence of self-defense in order to convict of murder.
That's where he began, actually, was the self-defense.
Yeah, he started instructing on self-defense, yes.
But he did tell the jury that in order to convict of murder, the Commonwealth had to prove beyond a reasonable doubt that the defendant did not act in self-defense.
Yes, yes. But he didn't go the next step further and say that as to Murder 1 and Murder 2, the Commonwealth also needed to prove the absence of excessive force in self-defense. In discussing the self-defense charge itself that you just mentioned, there was no mention about how what would happen if the Commonwealth, if the defendant used excessive force in self-defense. So the self-defense instruction itself did not mention the consequence of excessive force in self-defense.
If you could turn to the first aggressor idea. I mean, if he were the first aggressor, then he may use self-defense only if he withdrew, and I gather there's no evidence of withdrawal here. Do you agree with that?
Well, there isn't, but he wasn't saying that he was saying that the victim was the first aggressor in this case.
And the evidence that the victim was the first aggressor comes entirely from him, I gather, correct? Is there any other witness who corroborated that?
Yes, Nason was in the car, and he said he saw the victim throw the first punch.
But it was Nason didn't say that he saw the victim have a knife. That's only from the defendant. Is that right?
He said he saw the victim throw the first punch. I don't think he said anything about seeing the knife. No.
But the defendant's testimony was that the victim had the knife, and somehow or another, the defendant, was able to wrest it from the victim's control.
Exactly. Yes. Right. Right.
And is his version consistent with Nason? That is, did he say that the victim first punched him and then pulled the knife, or does he simply say he pulled the knife?
Well, Nason just comments on the victim throwing the first punch and being the aggressor.
Right.
He doesn't comment on, I don't believe, on Correa pulling out the knife.
No, but the defendant himself, did he, in terms of the sequence of events that he described, was it he first slugged me and then he pulled out a knife, or does he make any reference of being slugged?
Oh, yes, the defendant says that all of a sudden Correa punched him, and then Correa pulled out a knife. Yes, yes, exactly. And so addressing further about the manslaughter instruction, the judge in describing that used permissive language, discussing it in terms of may and should, rather than the obligatory must.
But on that point, if that were the only problem, aren't there a number of cases where you would be justified in, which we've said isn't great, but it's okay?
I'm not sure I understand your question.
Well, you say it should have said you should find him guilty, you may find him guilty of manslaughter. And you're saying, no, it should be, you must find him guilty of manslaughter. And I'm just saying that and I cannot remember what they were, but other cases in which the instruction given did not use must, it used some other expression, whether it was should or you would be justified in. And I think this court said it wasn't the greatest, but it was not reversible error by any stretch.
Well, I think you have to read in its entirety, and in this case, there's both must and should, and the overall tone is that it was permissive. So it's just not these words, it's the whole instruction on it. Left it optional to the jury, especially in light of the fact that there was no other instruction anywhere else about excessive force in self-defense, other than in this limited section of the charge.
Right, but the first may was not you may find him guilty of manslaughter. It's that the defendant may be found guilty of no more than manslaughter. So that doesn't seem to pose the same problem of the defendant may be found guilty of manslaughter. That basically says he may not be found guilty of anything more than manslaughter.
Well, again, I think it's the overall tone of instead of saying that if the requirements of manslaughter have been satisfied, you must find for this, it's left optional by saying, maybe nothing more than this you can find the defendant guilty of.
But isn't that also a reminder to the jury that they can find him not guilty? They're not directed to find him guilty of manslaughter. They could find him not guilty.
Well, if it's in terms of excessive force in self-defense?
Yeah.
Well, if it's excessive force in self-defense, they wouldn't be able to find him not guilty. It would be manslaughter.
Well, if you say must, then they would have to find him guilty of manslaughter. But if you say may, they could find him not guilty.
But it was in the context of if the Commonwealth proves beyond a reasonable doubt X, Y, and Z, then
Yes.
you must.
Yes, yeah. So I guess my point is that the overall tone of the language on this instruction was not that if the requirements of manslaughter are satisfied, you must find for this. It was optional, and I think if you couple that with the prior instruction on murder 1 and murder 2, where there was no discussion about excessive force and how excessive force figures into proving those charges, I think overall the charge does not convey to the jury the message that they must convict for manslaughter if there was excessive force in self-defense.
The model instruction at the time, the 1999 model instruction, doesn't say that much. It says if the Commonwealth proves beyond a reasonable doubt that the defendant used excessive force in defense of another, then you should return. That's what the model instruction said at the time. Of course, I know we viewed it differently in Santos. How different is what this judge did than what the model instructions provided at the time?
Well, I'm looking at the addendum page 3, which is the model instruction from 1999, and that talks about how the second sentence is, if the Commonwealth fails to prove beyond a reasonable doubt the absence of self-defense, your verdict must be not guilty with respect to the crimes of murder or voluntary manslaughter. If, however, the Commonwealth does prove excessive force or an effort to defend oneself, you would be justified in finding the defendant guilty of voluntary manslaughter, which I think addressed Judge Spina's comment that the wording would be left open to finding a not guilty verdict rather than saying you must find manslaughter. Addressing the third argument, Your Honor, if you don't have any further questions on that. The third argument is as to the prosecutor's cross-examination of the defendant and the improper violation of bringing to the jury's attention that the defendant had remained silent.
Are you, Ms. Blackman makes a distinction between silence with respect to people, not police, people that one might expect you would talk to, and police.
Yes.
Do you make that same distinction?
Yes, I talk about that in the Boronsky case in the brief. And the Boronsky case does say that if it would have been natural for a defendant to have made a comment to a civilian, then that is a proper question that can be asked.
Of course, in that case, had the defendant said anything to anybody in Bronsky?
I'm not sure, Your Honor.
Because I think, isn't there a distinction that needs to be made about total silence and having made a statement that's incomplete? Here we're really talking about either silence as an admission or prior inconsistent statements. Because he talked to people. He wasn't silent. There are certain things that he didn't say.
Well, the evidence was that he talked to people and inquired about the victim's health, how he was doing.
And he said he hadn't been involved in a stabbing?
I don't know if there was evidence about him saying that to the other people he was asking about the victim's health about. Okay. So in this case, there were three violations as to the defendant's silence. The first was the prosecutor asked the defendant on the stand, "Is this the first time that you've made this claim of self-defense?" And I notice as to that clear violation, the Commonwealth makes no comment about it in its brief. It doesn't even attempt to defend that. That is a complete improper question. The second violation was in asking the defendant on the stand, "Did you go to the police and tell them you were defending yourself?" And that also was a violation. The defendant had no obligation to talk to the police or to offer any exculpatory version to anyone. And the third one is the issue we just addressed as to the civilians. And as to the question of whether or not it would have been natural for him to go and tell the civilians what had happened, keep in mind that after this incident, he gets into the car with his friend. His friend was supposed to drive him to his grandmother's house, but his friend quickly abandons him and says, "No, I'm not driving you there." And he dumps him off at the Stop and Shop. He then calls his grandmother, whose house he was supposed to go over to. He doesn't want to go over there anymore. He has the grandmother drop him off at his friend's house. He's making phone calls. He knows that the victim has been hurt. He knows one way or the other he's going to have some kind of entanglement with the law. Under all these circumstances where his friend is backing off, he no longer wants to go to his grandmother's house. He wants to minimize his grandmother's involvement in this. Under all these circumstances, no, it wouldn't be natural for him to go and say anything to anyone about what had happened. And I think this should have been addressed on a voir dire, as the Nickerson case suggests.
But let me just ask you, and I'm somewhat revisiting the last point. When he was in the car with Nason and Wright, and this is at page 18 of your brief, you say, as they drove, the defendant said that he had stabbed Correa and added, "I hope I didn't kill him." So, I mean, he did say a lot about what had happened.
He did, well, he said something, but as far as, getting into exactly what happened, about who was the first aggressor, at what point did Correa pull out a knife, whether or not he was using excessive force and all that, as far as, when he jumped into the car, he swore and said, "Let's get out of here." It was a quick-paced turn of events, and I think maybe it would have been natural for him to disclose what he did say here, but to go on beyond that, especially as I say, as they were driving, Nason turns on him and says, "I'm not going to drive you to your grandmother's house." I can see him clamming up at that point, not saying anything. But again, this is something that should have been addressed on a voir dire. The prosecutor should not have just come out and asked these questions of the defendant without clearing them with the judge ahead of time, and there should have been a judicial finding beforehand about whether or not it would have been natural for the defendant to have said something. And that's per the Nickerson case, Your Honors. Moving on to the fourth argument, Your Honors, in regards to the prosecutor's closing. The prosecutor made arguments about the victim having a constitutional right to live, about the rights of the victim to associate with whomever he wants and to be there that night, and also about the victim is entitled to justice and that the victim's life mattered. None of these were issues in the case. The only point in any of these arguments was to elicit sympathy for the jury for the victim. The prosecutor also made the argument that the defendant had testified that the victim was a tough guy. And the prosecutor argued, well, where's the evidence of this other than from the victim's the defendant's mouth himself? And clearly suggesting that there should have been some kind of corroboration and that there was no evidence that had been produced by the defendant.
How big was the defendant? How tall was he, and about how heavy was he? And does the record reflect that?
I don't know the exact measurements, but there is reference to the victim being 10 years older, according to the defendant, but he was actually 12 years older. And also the defendant testified that he was a bigger guy than him.
If the jury looked at the defendant at trial, what would they have seen in terms of size?
He's not a huge man.
So he's not
size.
12 feet tall?
No.
But, is he 5 feet 6 feet?
I don't know his exact dimensions, Your Honor. I would say he just looks to be a regular person. Not exceptionally small or large, just regular.
The autopsy, or the pathologist testified that the victim, Korea rather, was, I think 68 inches, 5 feet 8, and was 175 pounds.
I'm not sure of that. I can say that the defendant testified that the victim was bigger and older. And also there was a reference to the victim being known as, I believe it was Big Mike. Mm-hmm. So he was known as being, by his nickname, a big man. And so that's the evidence on.
What's wrong with the prosecutor saying what he said about the defendant claims victim was a tough guy, but there's no other evidence of that? So what? Defendant put on a case here, didn't he?
Well, I discussed that's the Adjunct case, where the defendant would not, evidentiary-wise, been permitted to introduce any evidence as to the victim's, whether or not he was known as a tough guy. Per the Adjunct case, the only relevant evidence is the defendant's state of mind about how he perceived the victim to be as a tough guy. And so, under the Adjunct case, the defendant would not have been permitted to offer any corroboration about the victim's reputation.
I'm sorry, was this case done before or after Adjutant came out?
This was 2012.
So it was post-Adjutant.
Yeah.
So the defendant would be allowed to offer evidence of prior bad acts of Mr. Correa, just not reputation.
Yes. But yes.
Unless he was aware of it.
Exactly, right. And then addressing the, if you have no further questions about that, addressing the defendant's closing. Again, the issue in the case was...
Do you mean the defendants or the prosecutors?
I'm sorry, the defense closing.
Oh, the statement about he used excess. He didn't rely on self-defense. He relied on excessive force in self-defense.
Oh, well, in defense's closing, he did not say that you should find the defendant guilty of manslaughter because he used excessive force in self-defense. He argued you should find the defendant guilty of manslaughter because the victim pulled out a knife, because he was self-defending himself. But that's not correct. And in light of the fact that most people associate self-defense with a not guilty verdict, it was utterly confusing for the jury as to why this counsel was requesting a manslaughter conviction when the defendant was engaging in self-defense.
But did the judge instruct that the Commonwealth had to prove that he'd used excessive force in self-defense?
Only in the context of the manslaughter instruction in the very last line of that instruction. That's it.
And so the defendant was clearly asking the jury to return a manslaughter verdict?
Yes.
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 Yes, undoubtedly, yes.
So there's no question that they were not disputing that the Commonwealth had proven that?
Yes, absolutely. He requested explicitly a manslaughter conviction.
Okay.
Right, and that's the point, is that I think counsel needs to, muster the facts in a way that shows that there was excessive force used by the defendant, which he did not do in closing, and second of all, he has to explain to the jury Why, in this case, you should find manslaughter because it was excessive force in self-defense.
But in this case, even assuming that the truth of your defense, that he acted in self-defense, even the defendant's testimony was that after he had disarmed Korea, he stabbed him.
Yes.
And the medical testimony indicates that he stabbed him 5 times. So, I mean, really, isn't this a strong case for excessive force in self-defense? And doesn't it really tremendously overshadow the possibility of a self-defense verdict in this case?
That's his point.
Well, I agree. It's a tremendous case for excessive use of force in self-defense.
Your point is that if the jury is going on what Mr. Griffin argued, that it wasn't clear that he was arguing anything other than pure self-defense.
Exactly, right. And the jury wouldn't get the connection of how a self-defense argument relates to a manslaughter conviction, which is what he was asking for. Exactly.
Thank you.
Thank you.
May it please the Court, Tara Blackman for the Commonwealth. The first issue I'm going to address is the jury instructions. The judge's instructions in this case made it very clear that the Commonwealth had to prove that the Commonwealth had to prove the absence of self-defense beyond a reasonable doubt, and that if there was evidence of excessive use of force, then there could be no greater conviction than voluntary manslaughter.
But the way that it was constructed, the judge gave an instruction on self-defense, and I agree with you that it was clear when he goes down to murder that the jury could not convict of murder if they found the Commonwealth had failed to prove he acted in self-defense. But the entire murder instruction, and more particularly the discussion of intent, malice, has nothing about mitigating circumstances, not a word. And it's not until much, much, much later in connection with manslaughter that I don't even think he ever used the word mitigating circumstances, but that you ever get any idea about excessive use of force in self-defense. So how would the jury be able to figure out that, when we're thinking about murder, we have to think about whether there was excessive use of force in self-defense?
Well, Your Honor, I think that you look at the jury instructions as a whole, and this is very similar to actually the instructions that were approved of by this court in Commonwealth versus Walker, which is another case.
I didn't think they were, but
it's missing a whole paragraph from the model instructions. That when at the very last paragraph on malice, the model instruction suggests that the judge should tell the jury that in order to prove malice, the Commonwealth has to disprove, any mitigating circumstances that might be present in the case.
Certainly, the judge did not mention anything about mitigating circumstances. That is correct in this case. However, that was in Walker, it was very similar. What happened was the judge instructed you have to prove the absence of self-defense beyond a reasonable doubt. Then the judge instructs on the crime of murder, explaining the element of malice and what malice includes, which the judge accurately did in this case. Then he went on to explain voluntary manslaughter and that if there was excessive use of force, then the jury may convict of no more than voluntary manslaughter, which, unlike my brother, I would suggest is, and I would say that as a matter of English usage, that was mandatory language, that was not permissive to say, may convict of no more. But I understand this court's concern with the absence of saying anything about mitigating circumstances. However, the model instructions, while they serve as a guide, it's not required that the judge say that as long as the jury instructions as a whole adequately convey to the jury.
But I think that's the issue, did it?
And It's this, and it's the Commonwealth's position that it did, and I would say that the case law on this supports that it did. And I look to Commonwealth versus Walker. I also point this court to Commonwealth versus Boucher, in which that case was problematic because what happened in that case was the judge, when explaining murder, did not even say anything about malice, and he also did it. The judge also instructed in reverse. So at first he instructed on the lesser included offenses, then he went on to instruct on the greater offenses, and he never made a distinction between voluntary manslaughter and the crime of murder having the element of malice, so that the jury could possibly think that malice and a mitigating circumstances, provocation or self-defense, were not mutually exclusive. But here it would have been clear to the jury, based on the judge's instructions as a whole, that the two were mutually exclusive. Also, you don't even get to excessive use of force in self-defense if the Commonwealth hasn't proven the absence of self-defense beyond a reasonable doubt. As this court said in Santos, the only way you get to excessive use of force of self-defense is if the jury's found there's some potential evidence of self-defense, and then it's whether there was an excessive use of force of self-defense.
But on that point, again, sort of the way these are constructed, it seems to me that it would be reasonable to read these, to understand these. First, you think about self-defense. Has the Commonwealth failed or not on that score? Okay, you only get to murder if the Commonwealth has proved no self-defense. You get down to where the judge is talking about voluntary manslaughter, and he uses the phrase about well, we're thinking about this if there's lawful use of self-defense. So it seems to me that a juror might think, we already rejected self-defense, so we don't have to care about this. Do you know what I mean?
I understand your point, Your Honor, but I think that as a whole, when you look at the voluntary manslaughter instruction as a whole, the judge made clear that if there was any evidence that the defendant was lawfully using self-defense and that exceeded that use of self-defense, so he brought it back. I don't think that at that point, the jury would have believed, well, now our only option is murder, to convict of murder.
I just think they might think, we don't care about this because we already rejected self-defense.
Well, if they have found that the Commonwealth, if they found that
already rejected lawful use of self-defense because
right.
They had to have it. Anyway, they've already rejected that, and that's the kind of opening gambit with the manslaughter instruction.
And I understand, Your Honor, but the fact of the matter is you can't even, if the jury was completely convinced that there was absolutely no evidence of self-defense anyway, then it doesn't matter because you really don't get the mitigating circumstance of excessive use of force in self-defense. It's not like provocation.
The word lawful in there that was troubling to me.
But the thing is, and my brother even concedes that it's proper to say you began by properly using self-defense and then you exceeded it. You exceeded that amount. You can't properly use something if it's not lawful.
Started with lawful. Well, anyway,
right.
Okay,
no, and the judge did start by saying lawful. I agree. But the thing is that you can't properly use self-defense if it's not lawful. It does have to be lawful in the beginning, and I think the cases of this court are very clear on that. The problem is when you exceed that amount, and that is where you run into trouble.
Speaking of provocation, I know it's not referenced in the brief, but I gather there was no reasonable provocation instruction here.
There was not, Your Honor, and there was no basis for one.
If the victim slugs somebody and then pulls a knife on him and then immediately thereafter he's stabbed, that would not be a basis for finding of reasonable provocation, or at least raise a reasonable doubt as to whether there was reasonable provocation?
Well, I would say that actually, Your Honor, so of course none of the evidence supported that except the defendant's own claims during his testimony, but you are correct that if the defendant had asked for one, perhaps he would have been entitled to one. The defendant did not request one. So I apologize, yes. But he did not request one at trial. There was never one requested.
So that's another issue we need to address in determining whether there was a substantial miscarriage of justice, because that's a lot cleaner than having to deal with the I mean, with that, you don't need to address a lot of issues of self-defense. You can essentially say the guy slugged him, pulled a knife, even slugged him alone may be sufficient to say he was provoked, and therefore there's a mitigating element.
Well, correct, Your Honor. I mean, that is not something that my brother has raised, but you're correct that even if you consider that, I think you'd consider it in light of all the other evidence. So you'd say, could have created a substantial likelihood of a miscarriage of justice, as Your Honor said, not to have given this provocation instruction. And I think when you look at, I would say the evidence in this case is really nothing short of overwhelming. We have 8 witnesses, nothing short than 8 witnesses actually testifying that it was the defendant was the one who not only started this, but kept going after the victim. We have no stab wounds to the body of the defendant, and we have 6 stab wounds to Correa, 5 which actually went into his body. So we have statements by the defendant beforehand saying 2 days within the incident, time of the incident, saying that he's going to go after Correa because Correa was flirting with his girlfriend. We have the defendant's statements following the incident to Nason and Wright and also to Voisin stating that he stabbed the guy and that he even told Voisin when he's telling him about how the whole incident happened. He says, I got a knife and it all happened over a girl. I went and got a knife, grabbed it, and went and slashed him. So there's actually, I would say the evidence is pretty overwhelming. So if you look in that in light of whether or not there was a substantial likelihood based on the fact that no provocation instruction was given, I think you come to the conclusion that it wasn't.
And it wasn't tried on that basis either.
And it wasn't tried on that basis. No, it was tried solely on the basis of excessive use of force and self-defense.
Closing argument.
Yes.
Isn't it fair to say that when a prosecutor tells the jury that the victim's life matters to the police and it matters to all of us, does that not invite the suggestion that if the jury were to find him not guilty, the jury were to be finding that his life does not matter to them?
I would argue no. I would say that the context in which it was stated was more that it was more of, 1, humanizing the victim, and 2, a response to defense counsel's argument. What happened was when defense counsel argued, and also when defendant even testified, he stated that he made it out that this victim, Correa, was a tough guy. He had a bad reputation. He pulled the knife on him. He even said, I wanted to approach him in a group of people, implying that he was scared of this victim. This victim was a bigger guy. So that was the implication. And what the prosecutor said was, you haven't heard much about this victim. All you've really heard is what the defendant told you about this guy, that he's some bad, tough guy who pulled a knife on the defendant. But 1, there's no evidence of that, which I think is fair based on the evidence that was presented. And 2, that no, that's not the case. His life mattered. First of all, he had every right to be where he was that night. He was not looking for a fight. He had every right to be where he was, and his life mattered to all these people around him. And his life mattered to all these people at the meeting, and these were all the efforts made to save him, all the resuscitative efforts made by the medical personnel, all the people who showed up at the scene, and I think that was fair to argue. However,
I thought I understood your brief to say he should not have argued those points.
I think that the life matters comments, my brief, I argued that was permissible. What was not permissible was for him to argue. So the prosecutor made 2 statements about the victim being entitled to a fair and just verdict. Under Drumgold, those statements should not have been made. And also something which I actually wrote on a letter to this court, I had stated that there was no right to live argument. I was actually in the second to last paragraph, the prosecutor did say that the victim had a right to live. I apologize for that error, and there was that statement, and that should not have been made under the Barros case and those line of cases. The court has said that is an improper appeal to sympathy. However, what the court looks to is whether or not then that is something that would lead to a substantial likelihood of a miscarriage of justice. And I would say that as a whole, when you look at the prosecutor's closing and also the cases in its entirety, it's not something that could have led to a substantial likelihood of miscarriage of justice.
What this is off the argument, but what is your response, Mr. Gordon said you didn't make one, to the question about, is this the first time you've ever said anything about it?
I would say that that was the last question. That went to, I believe that was after the questions about the properly admitted questions about the defendant not saying anything to Voisin, to his grandmother, to Nason and Wright. And that was part of my argument, even though I didn't specifically say that, talk about that question in my brief. My brother is correct. That was part of my argument, that those questions are okay, and even that last question was okay because the prosecutor was discussing questions, statements that it would have been natural for the defendant to make under those circumstances. He did not tell his story to any of these people when he was telling them about what happened, and his whole explanation to Nason and Wright, I poked this guy, and he didn't. It's not like he didn't make statements when he's crying uncontrollably to his grandmother, apparently, or according to him, when he's telling Voisin about what happened and telling him that this all happened over a girl. He even said to Voisin, I grabbed a knife. In no time does he say, I was only acting in self-defense. It would have been natural for him to say it to these people when he's right after the event when he's telling them what happened, but he doesn't. And I think Nickerson and Bernowski are very clear that a prosecutor is entitled to ask the defendant about statements that he didn't make when it would have been natural for him to speak under those circumstances.
You mentioned earlier that, and you say towards the end of your brief, that none of the witnesses to the incident saw Correa so much as strike the defendant during the altercation. But I thought that Nason said that he struck him.
Well, he actually said, so first of all, his testimony was a little bit all over the place, but what he testified to on direct examination was, yeah, I think I saw a punch. And then when the prosecutor asked on cross-examination, did you even see that punch land, the Nason said no. So in fact, he never even saw anything actually happen, and that's pretty much consistent with his own testimony. And he was the only, and again, his testimony was all over the place. He was contradicted on many occasions, but even on cross-examination, he admitted that he never even saw the punch land, which he claimed that the victim threw.
Let me just ask you one quick question. I was sort of looking through the briefs, looking for, to determine whether or not defense counsel had, at the end of the jury instructions, gone up and pointed out to the judge that they were lacking in some respect.
Absolutely not, Your Honor. Okay. There was absolutely no objection to anything during the trial. The defense counsel just asked for the instructions that were given in the sense of murder, voluntary manslaughter by excessive use of force, of self-defense, and everything, any claims that have been brought in this case, nothing was objected to, and I think my brother concedes that in the brief. Everything is looked at under substantial likelihood of a miscarriage of justice standard in this case.
With regard to the question on cross, which was effectively, did you call the police to tell them that you were just defending yourself?
I actually wanted to get to that, yes, Your Honor. I think that is the next important thing that we do get to, because I think part of that question was okay. The part of the question, it was part of a compound question. Did you call the police? And that was part of the question where this is part of a line of questioning where the prosecutor is asking the defendant about his alleged concern for Correa. He was entitled to impeach him and show why that was not credible. Where we run into problems is the prosecutor's second part of the question, which is, did you tell the police your side of the story, basically, that you were just defending them yourself? That should not have been asked.
It's okay to say, did you talk to the police?
No, well, it was asked in...
forget your side of the story. It's okay to say, did you call the police?
Yes. That was, if you look at Bernowski, if you were asking in a line of questioning to impeach the defendant, to show that if you were so concerned about the victim, did you do this in a sense of, did you get help for the victim? So that was okay. And that was actually how that line of questioning, that was exactly what the prosecutor was doing. He was saying, okay, you were so concerned about Correa. If you look at the questioning of that, did you call the ambulance? Correa says no. The defendant says no. Did you call the police? That he says no. But the problem is that's part of the compound question of, did you call the police and also tell them your side of the story? That should not have been said. But it did not create, it would have not created a substantial likelihood of a miscarriage of justice, and this is why. One, It was not something that was heavily focused on as in the prosecutor's cross-examination. It was part of a line of questioning clearly going toward whether or not the defendant was really disconcerted about Correa as he contended he was. Number two, it was not something that was even mentioned, referenced at all in the prosecutor's closing argument. And number three, it was not something that was mentioned in, it's not a situation where the judge in his instructions said, you can look at the defendant's pre-arrest silence. In cases that have warranted reversal on this basis, the cases cited in the defendant's brief, Commonwealth versus Irwin, there are different types of circumstances. There are circumstances where there wasn't a lot of evidence against the defendant. Maybe it was just eyewitness testimony. The pre-arrest silence was something that was stressed by the prosecutor and then pointed out in the closing argument. This is not that type of case. The prosecutor didn't even reference it in his closing argument. I think that the evidence in this case was, like I said, nothing short of overwhelming. And also, more importantly, and I actually want to note one of the cases that's actually relevant is Commonwealth versus Thompson even says in that case, and I don't believe it's cited in my brief, but it is one of the cases in these line of cases. And it says that when it was another case where a pre-arrest silence question should not have been asked. But the reason why the court even said could not have created a substantial likelihood of evidence because it was also cumulative of all the other evidence that was inconsistent with the behavior of an innocent person. Here, so, okay, yeah, we have this one question that perhaps problematic about the pre-arrest silence of the police, but we have all this other evidence that was properly admitted. I state under Commonwealth versus Bernowski and Commonwealth versus Nickerson that, look, this defendant would have been natural for him to make all these statements to all these people when he's saying about his whole story about what happened. He never tells any one of them this. Instead, he tells all of them basically he attacked Correa. He went and got the knife. We have 8 eyewitnesses to this corroborating this, and then he tries to get rid of the evidence and hides in a cubbyhole. And so I think that in these circumstances, this was such strong evidence. I don't think this is the type of case where either that one single part of a compound question or a couple of statements in the prosecutor's closing where he says about the just and fair verdict or the constitutional right to live or some right to live, while perhaps error would have created a substantial likelihood of a miscarriage of justice. And I also, one last thing is I do want to mention the prosecutor during his closing did mention, in addition to the judge, of course, not to be guided by sympathy, that the defendant was entitled to a fair trial. And I think that what the prosecutor clearly was doing in this case was not trying to obtain a verdict on sympathy. These were errors, a couple of errors that things he shouldn't have said, but I think it was made very clear to the jury, both during the prosecutor's closing and definitely during the judge's forceful instructions. Empathy, sympathy were not to be guides in the case. It was the sole evidence.
One question which does not bear on the outcome of this case. You've had to work very hard today to address certain things which you quite properly concede to be error and quite properly argue to us should not justify a reversal. Is there a practice in your office to be informing trial prosecutors of certain do's and don'ts in closing and on cross of a defendant so that you don't have to work so hard next time?
Absolutely, Your Honor. The prosecutor has been made well aware of that the comments about the fair and just verdict and
This prosecutor or all your prosecutors?
All of our prosecutors are made aware of these facts, yes. So I think sometimes just when you're arguing a case, I think you get impassioned and you make some statements that perhaps would have been better left unsaid. I think certainly, though, the prosecutor, by starting off and reminding the jury.
Again, I'm not related to this case.
Yes.
I understand that.
It's just a matter of. Yes, there is. Yes.
There's a concern about whether or not your prosecutors are well enough informed about certain things so that you don't have to work so hard next time.
Of course, Your Honor, yes.
All right, thank you.
Thank you.